Well, I've been looking into the sort of Lucy Letby matter. I've been looking at sort of, other similar cases, both here and abroad. But this reminded me, because you're not a historical sort of nerd I am, about the first time in English law that they tried to convict somebody of the M word purely by expert evidence, because the issue was not just whether this person had committed the offence, but whether an offence had been even committed in the first place. And it's a really interesting case, and it may be that you've heard of it, but I thought I'd go into some of the background, because apart from anything else, it also sort of changed the law in lots of areas. And also there's sort of all scandal, there's threesomes between judges, MPs and the suspect, there's tales of corruption behind the scenes, sort of like government leaning on judges, judging leaning on government. So it's all very interesting. So who am I talking about? I'm talking about somebody called John Bodkin Adams, and unusually for me, I've actually made some notes because there's some quite fascinating sort of facts here. John Bodkin Adams was a doctor. He was quite, a very popular doctor. I mean, it reminds me a bit of Dr. Shipman, really, where he sort of had lots of ladies of a certain age who thought he was like, the best thing since sliced bread. And lots of his clients would give him gifts and indeed leave things to him in his will. And in 1922, he borrowed £2,000 off one of his patients. I'm not quite sure what £2,000 is in sort of modern money, but he was able to buy a huge house in one of the poshest parts of Eastbourne. So, must have been quite a bit. But he carried on with his sort of practice. However, suspicions arose about the death rates of his patients. And there were some rumours that did sort of rumble around all the time. Apparently people were sending him postcards going, "We know what you're up to," and things like that. But other people said, no, it's just scandal and gossip. People are just jealous. Because apparently he ended up being the richest doctor in England. He had a massive practice. I mean, and during the war, he studied as a doctor. It's obviously a reserved profession, but he studied to be an anaesthetist as well, so he could self-administer anaesthetic to patients. But in the 50s, this all grew to a bit of a head, because what was happening is he was seeing people, and he used opiates for pain relief, especially for people who needed palliative care, or so he claimed. However, one doctor stepped in and took over a patient, and the patient, when he arrived, she'd been like completely stupefied. She was completely out of it on morphine, and he took care of her, and he said, well, she doesn't need this stuff. So he withdrew the morphine, and after 8 weeks, she was thoroughly back to normal. And this sort of aroused suspicions. So eventually, the Attorney General was minded to actually prosecute him. And like I said, there was a lot of pressure behind the scenes of people, because he was a very popular person, John Bodkin Adams. I mean, indeed, one of the magistrates, one of the preliminary hearings, he had to step down because he was a personal friend, and they did have a lot of trouble, sort of finding people he wasn't connected with. There'd also been rumours going around that there was some weird three-way thing going on between an MP at the time who was very supportive of Dr. Adams, one of these sort of like senior magistrates in the area, and Adams himself. So this was the sort of thing that he was up against. And there was this thing as to, is it just scandal and gossip because he's quite unconventional, or people are jealous of him because of his income and that's why other doctors don't like him? But anyway, the Attorney General was moved to prosecute. Now, there were suspicions that he'd actually bumped off hundreds of people, but they concentrated on 4 suspicious deaths. And they had what were called committal proceedings. Now, the Attorney General took the view that it was just going to prosecute one at a time, which again was quite a controversial decision. So at the committal proceedings, one of the issues was that they said, we just want you to commit on one murder, but we're going to put 3 in. We're going to say there's 3 other suspicious ones as well, to give you a sort of course of conduct, a pattern there. What are committal proceedings? It used to be that before you could prosecute somebody, you had to show there was a prima facie case to answer. Now, it used to be we used to use grand juries for that, like they still do in some places in the States. So the prosecutor would turn up. There was no defence. The prosecutor would turn up to a panel of like lay people and say, this is the evidence we have. Do you think there's enough here that we should initiate a prosecution? And there's all that sort of idea that a decent prosecutor should be able to get an indictment against a ham sandwich because it's totally one-sided. This is everything, all the evidence we've got. You're not going to hear what the defence is. That's for trial, but is there enough to bring them to trial? That changed, and we had what we call committal proceedings, which is a similar procedure but in front of magistrates. So the prosecutor comes along, lays out all the evidence, and then the magistrates decide whether there is a case to answer. And there's quite some controversy there because of the fact that they mentioned all these other suspicions even though they were only prosecuting one case. Now at the time, committal proceedings, they were open to the public. And there was lots of press reporting about that. And we got into the old thing about, is this going to prejudice a trial? Because you're only going to prosecute with one. Are you going to murder? Are you going to mention these other? Are you going to mention these other cases even within the trial? Because generally speaking, at the time, you couldn't put in bad character evidence. However, they said, well, this is an exception because it's showing a similar fact evidence. But they said, well, yeah, but either you can't just come with suspicion. And obviously the press jumped on this, sort of like a doctor who's sort of supposedly bumped off at least 4 people and the suspicions of hundreds more. And that caused quite a lot of prejudice, or people think it did. So the first law that was changed as a result of this case is committal proceedings ended up being private. They became a private thing. We don't actually have committal now. We've had what we used to call, I'm old enough to remember when we had old style committals and new style committals. Old style was where you just read out all the evidence. New style committals are where you just sort of said, we have some evidence. That's all gone now because pretty much every single time the magistrates would go, yeah, it's fine. So now we just have either the magistrates accept jurisdiction and get on with them themselves, or they send it to the Crown Court and let the Crown Court deal with it. You can put in an application and say there is no case to answer before it gets to trial and say, look, even if you believe everything they say, the prosecution say and they can prove it, this still doesn't amount to an offence. But the onus now is on the defence to raise that rather than it being a standard practice. There was some controversy because the first case they decided to go with was where the deceased person had been cremated. And they said, oh, well done, because the evidence is that he's poisoning them. He's bumping them off with morphine. And they said, we won't be able to show there's any morphine there. You should have gone with one of the others who were buried. But they actually did exhume some of those people. And the scientific evidence at the time was, well, you can't really tell now because, after a while, they didn't have the sort of sophisticated ways of testing sort of post-mortem for the presence of drugs. But his defence was, this is palliative care. Yes, I go along and I do inject people with morphine, but that is just to sort of, give them some relief. And yes, it is a little bit of easing their passing. And the other law that came in on the back of this is a so-called double effect rule. So what's that? Well, let me explain. Say you see somebody jumping off the top of the Empire State Building, and 10 feet before they hit the ground, you shoot them with your sniper rifle. Do you commit an offence? Yes, you do. You commit the M word, because it doesn't matter that a fraction of a second later, it would all be irrelevant and they'd be dead anyway. The fact is you have shortened their life, albeit by a fraction of a second. But what the court established was that where people, and it's interesting because the BMA say it only applies to doctors, but if you read the law, it doesn't seem to distinguish between doctors. It says where you are giving people pain relief, for pain relief, even if you know that will actually shorten their life, it's the double effect rule. So that doesn't amount to the M word, because yes, you are taking a deliberate act to shorten their life, but the fact is you're doing it, it's effectively a mercy killing. And at the time, remember this was sort of in the 50s. Remember, I think it's pretty much an open secret now that the Queen's father was euthanized. Some people suggest that he was euthanized at a particular time so they could report his death in the morning papers, which was considered to be classier than reporting his death in the evening papers. So this all went to trial. And what's interesting is, and this is the third bit of new law, the judge specifically said, because unusually, Adams did not give evidence in his own defence. The prosecution said, there is no case to answer here, so we're not going to even acknowledge this case by sticking our client in the box. Now, the real reason apparently was he was very loquacious. and he was very chatty, and he didn't think he'd done anything wrong. So they worried that they might just give him enough rope to hang himself. And this is interesting because at the time, this was another thing where, at the time, a death by poisoning couldn't attract capital punishment if it was a single death, but if it was two, then it could. But they only prosecuted him one at a time. And there were also people saying, well, hang on a second, why have you done that? Have you made a deliberate choice to prosecute these individually just so there's no risk of a death sentence? But what's interesting there is, even though obviously we had the right to silence, unlike now where they can draw the adverse inferences, but the judge specifically directed the jury and said, the mere fact that he has not given evidence, do not draw any inferences from that. He's perfectly entitled to. And that which seems to be the first time that the jury had ever been given an explicit direction that they couldn't hold somebody's exercising their right to silence against them. But anyway, what happened? Well, he was duly acquitted. Now, what's interesting here is he'd actually been remanded in custody. And the defence had planned to apply for bail because they knew this second trial was coming. And what they said, well, look, just, arraign him for this other one that you're going to go for, and we'll go through it, and he's bound to be acquitted again. And because he was, you just had this trial in front of the judge who's, been pretty disparaging about the prosecution case, they thought they had a good chance for bail. But the Attorney General at the time, Mr. Manningham Butler, who was, quite a famous person, he issued what's called a nolle prosequi. That is where the Attorney General, on behalf of the state, says, we will not prosecute this person. Now, the judge, that's Judge Devlin, who later became Lord Devlin, he was absolutely, he was furious about this. And he sort of wrote to various powers that be, and he was quite loquacious and said, this is an abuse of process. Because the whole point of nolle prosequi is, it's meant to be where effectively the state says it's not in the public interest to prosecute this person. Yes, you might be able to prosecute them, but it's not in the public interest. Sometimes it was used for, like, say for instance, if people agree to give evidence, turn Queen's evidence, as we used to say. So it's a suspect, I will give evidence against everybody else, but I want to guarantee you're not going to prosecute me. We'll issue a nolle prosequi. Or we accept that the way that this case was investigated was very egregious, so it wouldn't be right to prosecute you, you wouldn't have a fair trial, the previous actions have nullified the chance of a fair trial, whatever anybody says, so we'll do a nolle prosequi. So the whole point of the nolle prosequi procedure is it's meant to be there, it's almost like a preemptive pardon. But what the judge says here is, you have used this to avoid the embarrassment of an acquittal. And you don't want people to see that this was just a terrible case. So again, that was another sort of little interesting thing. Now, it's fair to say, Bodkin Adams, he was successfully prosecuted on some offences, because when they turned up at his house and raided it, looking for, drugs and things, they found out he wasn't keeping, doctors at the time were supposed to keep a register of when they, what potentially lethal drugs they actually had in their possession. And he didn't keep the register. Now, it's fair to say that at the time that was not even slightly uncommon. It was generally most doctors. Some doctors would keep the register, but most wouldn't. It was just like, I'm a doctor, I know what I'm doing. Because all you had to do was sort of say what drugs you had in your possession. You didn't say how you were prescribing them, or how much you had, or who you were prescribing them to, or why you were prescribing them. You just had to say, I have in my possession these. So most people thought, well, what's the point of that? So he was successfully prosecuted for breaches of the medical regulations in not keeping sort of various bits of paperwork. And he was actually struck off as a doctor. However, he actually appealed twice, and within 2 years he was back on the register and he was practicing. Now, obviously lots of people commented about this and lots of people were suspicious, but he successfully sued loads of newspapers for suggesting that he might be guilty of any offence. I mean, there were other people saying, he's just doing it for the money, all these people keep leaving him money. Somebody did comment and say he once turned up at a house where one of his patients had died and sort of said to the widow, oh, I'm sure your late husband would like me to have a memento because we were such good friends, and he took a really expensive gold pen and said, just something to remember him by, and then never turned up again. But, is that evidence, of the M word? He might have been a bit of a shifty character. But like I say, he continued to sue people all the way up until his death. He died in 1983. And like I say, even to his death, he was still receiving legacies from his former patients. So there you go. So, like I say, it was an interesting one though, because they had to use expert evidence because it's, well, we don't have the body. We've got no idea how this person died. So all we can do is get the experts to come in and look at how he was acting in his practice. And they actually got lots of nurses to give evidence against him, and sort of, their witness evidence was, oh, this is all slightly shaky, and we've got, we have problems like this. But the defence somehow got hold of the nurses' private notes. They were never asked how they got hold of them, but they did, and that showed that contradicted the nurses' witness evidence, which again did not look good because they only got those notes on the second day of the trial. So the prosecution lay out their case, call all these nurses, and then they will say, ha, we have just found all this evidence which we can put to you to discredit you. The other thing that was a change in the law at the time was the British Medical Association, or Council, whatever it's called back then, the Doctors Association, said doctors cannot cooperate with the police. It's a breach of client confidentiality, even if the client's no longer around. And what that meant is no other doctors could comment on the behaviour of other doctors. So you couldn't sort of say, well, doctor, what do you think of, this treatment? Or, now you've seen this patient as well. They were told that they shouldn't cooperate. As it happens, that seems to have been a little bit of a tactical move, because at the time this was the NHS was had been born by then, and apparently this was doctors. They were going like, we want a pay rise. And one of the bits of leverage, they said, if you don't give us a pay rise, we're not going to cooperate with anybody. However, again, the Attorney General lent on the head of the Medical Council and sort of said, look, here's all the evidence we have against this guy, including all the stuff we're not putting into the public yet. Come on, do you really want one of your guys going around bumping off hundreds of people? So they did actually they disclosed their own internal notes on Adams, because they'd been keeping an eye on him themselves. So they said, okay, here's a 150-page report as to all our suspicions. But what's interesting about that is that report also ended up getting leaked to the defence. And some people have suggested that it might have been the Attorney General himself who leaked it, although I'm not sure about that, because he seemed to be putting his career on the line to prosecute this guy. Why would he help the defence? But people said it might have been somebody else in the Attorney General's office, or somebody else in government, or it might even have been the Medical Council themselves who said, oh, just to let you know, we've let the AG have this, so you need to know about this. So there are all sorts of things going on in the background. And I just find it interesting that I suppose if we'd had social media back in those days, what would people be thinking about this? But like I say, he was never convicted of any of the M-word offences. He was convicted of some regulatory offences about his record keeping, but he went on to have a fantastic practice, and like I say, possibly the richest doctor in England. So I'll let you do your own research if you want to follow this up. I mean, was he just some angel of mercy who was relieving people in their last hours, or was he somebody who was bumping people off either because he got a thrill out of it, or just because they'd left him money in their wills? Who knows? I mean, what's interesting is all the notes about this that were kept under seal, they were meant to be kept under seal till sometime in the 2040s, but now, after a campaign, they have been released. So they're all in the public domain, so you can all go out there and read them for yourselves, and make your own minds up. But anyway, just thought with everything that's going on at the moment, you might find that, as always, vaguely interesting, vaguely informative, and vaguely accurate.